Supreme Court rejects affirmative action programs at Harvard and UNC. The court had previously supported considering race as one factor to encourage diversity in education. However, the Supreme Court recently ruled against affirmative action in colleges and universities across the country. They deemed the race-conscious admissions programs at Harvard and the University of North Carolina illegal, significantly limiting a long-standing practice in higher education. The court's liberal members dissented, resulting in a 6-3 vote. According to Chief Justice John G. Roberts, Jr., the admissions programs at Harvard and UNC cannot be aligned with the Equal Protection Clause. He argues that both programs lack clear and measurable goals that justify the consideration of race. Additionally, they inadvertently perpetuate negative racial biases, rely on stereotypes, and lack meaningful ways to determine their effectiveness. Justice Sonia Sotomayor expressed her dissent during the court session, which is an unusual action, indicating strong disagreement. She emphasized the importance of affirmative action in addressing ongoing and organized racial discrimination. In her written dissent, she criticized the court for undermining the constitutional guarantee of equal protection and perpetuating racial inequality in education. This decision is likely to result in a decrease in the number of Black and Latino students and an increase in the number of white and Asian students at elite institutions. It is also expected to create challenges for schools in reviewing their admissions practices and may complicate diversity efforts in other areas, making it more difficult for highly qualified minority candidates to be considered for employment based on their race. In her written dissent, she expressed concern that the court's decision undermines the principle of equal protection guaranteed by the Constitution, perpetuating racial inequality in education. This is particularly troubling as education serves as the foundation of our democratic government and pluralistic society. The University of North Carolina case involved allegations that the university engaged in discrimination against white and Asian applicants by favoring Black, Hispanic, and Native American applicants. The university defended its admissions policies by arguing that they promote educational diversity. This ruling highlights the court's conservative supermajority's proactive approach in addressing highly contentious issues such as abortion, guns, and now race within a short span of time. It also raises questions about the impact of President Donald J. Trump's appointment of 3 justices on the court's direction and the stability of the law and the court's credibility, given that the decision overturns more than 4 decades of precedent. Public opinion surveys provide a complex outlook on the public's stance towards affirmative action, and the results vary depending on how the questions are framed. However, overall, programs that consider race in admissions are not well received, indicating that the recent ruling is unlikely to spark a backlash similar to the one seen after last year's decision regarding abortion rights. Critics, particularly Democrats like President Biden, strongly criticized the ruling as a regression. In a televised speech shortly after the ruling was announced, President Biden called on the nation to ensure that this decision does not mark the end of the discussion on affirmative action. Discrimination continues to persist in America, he emphasized. Today's decision does not alter that fact. When a reporter asked if the court could be considered rogue, President Biden paused before responding. This is not a typical court.